Lachowski i Piątkowski o prawie międzynarodowym. Podcast Wydziału Prawa i Administracji Uniwersytetu Łódzkiego oraz portalu Obserwator Międzynarodowy.
Szanowni Państwo, drodzy słuchacze, dziś odcinek specjalny. Jest z nami profesor Lauri Mälksoo i ta rozmowa odbędzie się w języku angielskim. Dear listeners, welcome to another episode of the podcasts Lachowski and Piątkowski on international law. This time it's a particularly special one as we are joined by an outstanding expert in international law, Professor Lauri Mälksoo. Lauri, thank you very much for accepting our invitation to the podcast.
Thank you for inviting me, Tomasz and Mateusz.
Thank you one more time. And very briefly, you would like to introduce our special guests. Lauri Mälksoo is a professor of international law at the University of Tartu in Estonia. He's a member of the Estonian Academy of Sciences and since 2021, member of the European Commission for Democracy through Law, the so-called the Venice Commission. Professor is also co-editor-in-chief of the Baltic Yearbook of International Law at Brill and belongs to the editorial board of Review of Central and East European Law, as well as academic advisory board of the Journal of History of International Law. Among many different publications, we can mention a very significant book, The Russian Approaches to International Law, published by the Oxford University Press in 2015. Actually, this book was republished in Polish language just after the full-scale invasion of Russia against Ukraine. And also we can mention the recently published the Oxford Handbook of International Law in Europe, co-edited by our special guest. Lauri, we met several months ago at the conference held at the Central European University in Vienna, which was organized by Patryk Labuda and Marek Wasiński. And this conference focused on the concept of the so-called Second World Approaches to International Law, the acronym SWAIL. And as the organizers indicated, the inspiration for framing the topic in this way was the intellectual movement known as the Third World Approaches to International Law, TWAIL, which has for several decades held a significant place in academic circles, especially the prestigious Western institutions. And we would like to ask you about your understanding of the notion of SWAIL, this new concept, both in terms of its substance and the geographic scope. And let's start with this, the latter one, so the geographic scope. Because during the Cold War, the so-called Second World referred to the communist bloc of states, with Moscow as its political center. And how do you perceive this notion of the Second World today, especially in terms of the war of aggression of Russia against Ukraine and the hybrid threats of the Russian state against our region? Would you agree that this the Cold War understanding of the Second World is kind of anachronistic? So, what's your opinion about this term?
Yeah, that's a very important question. I'm not sure there is a second world, to be honest, in the sense that, communist world is gone. And I think what used to be a communist world, it is quite different states nowadays. I mean, I have been interested in the intellectual history of how international law was understood and conceived of at the time of communism or real socialism, and all these efforts to create socialist international law. I am aware of these, let's say, Soviet-Chinese complicated relations in the history of international law. But today, even in the context of the UN, I think that, for example, the country group of East European states is to an extent anachronistic because it's no longer at least not a politically uniform group. It is, yeah, maybe geography is something that both Poland and, let's say, Belarus share, but it's not a community that it is all sort of looking in the same direction. I think so. I took the conference in Vienna as an interesting proposition, something to ponder, something to think about, because I think the organizers of the conference and people who framed this idea, which can also be understood as a sort of wordplay or joke almost, I think their starting point was that even let's say after the end of communism, those inequalities are not over, and the alignments in the world can be very, very, very different. So although countries like, let's say, Poland and Estonia, they joined both the European Union and NATO as well. They have a special situation because to some extent, they are also still struggling with the ambitions of greater neighbors nowadays, particularly the Russian Federation that started the war in Ukraine. So my own interest in this story is particularly this. I think that sometimes in Poland there's a concept intermarium, basically this belt of usually smaller states between Scandinavia, starting perhaps with Finland, the Baltic Sea, up to the Black Sea, nations that were born mostly after 1918 from former empires, and that were indeed under, either they were annexed by the Soviet Union like the Baltic States during the Cold War, or they were under some sort of Soviet hegemony. And then the Soviets would also use force against those countries, like against Hungary in 1956 and Czechoslovakia in 1968. So my own interest belongs to that group of states that is, on the one hand, Europe, obviously, historically, culturally, but even so, it is not somehow uniform. So think of Serbia. It is not member of the EU, although it constituted the core of the country called Yugoslavia, which played such an important role during the Cold War. So a lot of kind of interesting historical geographic situations in that belt of states.
Thank you, Professor, for your remark on the interplay between the politics, geography, and the law. But I would like to move furtherly to the content of the second word approach to international law. And here I would refer to the text that was published in 2022 by Hungarian author Professor Tamás Hoffman from Hungary, when the text titled "Should the East Have a Voice? International Legal Life on the Semi-Periphery." And there is a question, because I think the main flow of this article is about highlighting that there are a lot of international legal scholars operating, researching in the area of Central Eastern Europe. They've been writing down a very important and fruitful submission in their own national language, Estonian, Polish, Lithuanian, Czech, Hungarian. Yet sometimes from maybe, overall perspective, especially global perspective, if you want to ask to which group the scholar from this region belongs in terms of, let's say, geographic or perceive geographically, most people outside the Europe would say, okay, this is a scholar from, let's say, so-called West. But on the other hand, maybe if you ask, let's say, those core Western scholars, whether the scholars from Central Eastern Europe
are part of the Western international law scholarship, they would say, well, not so much, or maybe it is a little bit more complicated, to put it this way, or as lawyers love to sometimes say, it depends, which is, in my opinion, a perfect description here. So coming back to the question, is the second world or Central Eastern Europe really a semi-periphery in the world of international law, being a younger brother of the West without its intellectual subjectivity?
Yeah, I think to start with, Thomas Hoffmann is a very interesting scholar, indeed, from Budapest, and he was present in Vienna at the conference on the Second World approaches as well, as you remember. And now the question, indeed, the link between the previous question, that one is it worth looking at Central and Eastern Europe as a kind of semi-periphery compared to the core of the West? And there is something to it, although one needs to then go in detail. So let me give you this example. We have currently, for example, a judge at the International Court of Justice, as well as from the International Criminal Court from Romania, as well as there is an International Law Commission's member from Romania. I have a particular interest and fondness to this country because my wife happens to be from there. So I'm in that sense, my interest in Central and Eastern Europe, goes further from my own country, Estonia. So we cannot say that Romania, in that sense, today is underrepresented. It is doing rather well in the practice of international law. At the same time, it is true that when we think of, people who get grants of the European Research Council or the majority of articles that are published in, let's say, most appreciated journals like European Journal of International Law, there is a little bit a tendency that they tend to be from West European universities, and sometimes there is also brain drain. It is more likely that very talented international lawyers from Central and Eastern Europe would end up in the Western core rather than vice versa. Think of Marko Milanovic, for example, one of the best known international lawyers of let's say, my generation. But I think it has objective reasons because this break of continuities, this break of systems, also the resources that after the collapse of the previous system in the late 80s, there was a phase when there was a clear, to an extent, we should say that Eastern Central Europe also has been more poor overall. There wouldn't simply be resources to let's say, create a Max Planck Institute of International and Comparative Law in Warsaw, even if Poland wanted it. At least I would guess that it would be hard to come up with the same amount of resources for the same purpose. So at the same time, it is also, I think Central and East Europeans, we did make that choice historically when we wanted to cherish our nation states that were born out of empires and that were relatively small as nation states. So it is obvious that when we want to have those nation states, there has to be some discussion about international law in Polish language. There also has to be some amount of discussion about international law in Estonian language. By the way, as a scholar, as a writer, I often get at least equally big satisfaction in doing things in my own language. In Estonian, because I feel that people are almost more thankful, or they, to some extent, these questions are really of genuine interest to the public. And the smaller the place, the smaller the language, the more easily you can to an extent influence things or explain things. Whereas in a very big country, let's say in the United States or perhaps even in Germany, there are just so many more international lawyers who can explain this or that. So I think that rather than complaining, we Central and East European international lawyers, we also need some kind of honesty about our situation. So what if in some ways it is better for us? I mean, except for the threat of war, of course, in some countries. But it's not only about money. It's also about the very specific question whether we feel well in our societies as scholars, as jurists, as researchers. Are we needed or not? And I think as Estonian, I can say that international law is traditionally respected as a discourse, as a field. There is much interest in it. There are doubts about it. People sometimes ask nowadays, is it still there? Can we still count on it? And these are valid and legitimate questions. But I'm thinking back in the 90s when Estonian president at that time, Lennart Meri, was asked about successful nuclear tests by India and then Pakistan, and he told to journalists that he thinks that the nuclear weapon of small states is international law. So I think it, to some extent, shows this almost overemphasizing the importance of international law, and it is also interesting to function in a society that realizes that somehow we need international law to exist, to survive, because the security, the existence of small states is never based on force only.
Yes, and little follow-up regarding your observation from the beginning of your answer. Actually, if we take into account the current situation in the ICJ, we actually, I believe, have two judges from the Central Eastern Europe, because we have Judge Tomka from Slovakia and we have Judge Aurescu from Romania, and it's actually a world court, 15 lawyers, great expert judges from all the different areas of the world, and we have actually two lawyers from Central Eastern Europe. So maybe we could talk here in this regard a little over-representation, but maybe this is not a very appropriate word. But on the other hand, I think we could say that, lawyers from Central Eastern Europe are visible in international institutions.
Yeah, and there is of course this nuance to those two seats that currently belong to Slovak and Romanian judges in the International Court of Justice, that up until 2 years ago, from the creation of the International Court of Justice, actually one of those two went earlier to the Soviet Union, and then after 91 to the Russian Federation. But as a result of Russia's aggression against Ukraine, I would say this must have been the political context of this. Russian judge was not re-elected, and the Romanian judge was elected instead. So there is this caveat, let's put it this way, that one of those two places, at least historically, was occupied by a candidate nominated by Moscow.
Yes, indeed. Thank you for this comment. You mentioned during the answer on the first question, you mentioned the concept of intermarium, and of course we have different versions of this concept. The core version is, I would say, something which is comparable to the geographic scope of the first Polish-Lithuanian Commonwealth, of course, with the part of Estonia belonging to this huge project of the Polish-Lithuanian but not just Lithuanian state in the 16th and 17th century. And having in mind this issue, I would like to ask you whether is there something, as we would say, the Baltic States School of International Law? Because in political and geopolitical discussions, those three states, Lithuania, Latvia, and Estonia, are almost invariably grouped together, which reflects, of course, their geographical proximity, but also their shared historical experiences and challenges in the fields of security, of international politics, and of course international law. Just before our recording, there was an information that Latvia was chosen to become the non-permanent member of the UN Security Council. And having in mind the activities of those three states, of Baltic states, in employing the instruments of international law, and I would here indicate the two groups. First of all, I would say the historical justice, so seeking accountability for Soviet-era crimes, which was very, very progressive in terms of all three countries, maybe with the Lithuanian state as a leader in this group of states. And the second group is the current response to Russia's aggression against Ukraine by the use of different international institutions. Lithuania was the first state that referred the Ukrainian case to, or the Russia's crimes on the Ukrainian soil to the ICC. Also, Lithuania started the proceedings against Belarus before the ICJ. So having in mind this kind of activities, the political, legal activities of the three states named Baltic states, can we identify within the academic sphere and the doctrine of international law some kind of the conceptualization or the emergence of the effort to conceptualize a distinct Baltic states approach to international law? How do you perceive this fact?
I would try to somehow generalize here and not to get stuck with specific policy areas like war crimes or crime of aggression, and my generalization would be that it seems that these three states, they understand themselves as small states objectively. There is, in fact, at least in Estonia, there has been since Estonia's restoration, at least in 91, debate, discourse, on the one hand, of the role of small states in the international community. In fact, when now Latvia is the third Baltic state who gets the chance to be a non-permanent member of the UN Security Council, but I think both Estonia and Lithuania, they have made some campaign with this, that they are also in some ways representatives of small states. But further from that, coming back to this Lennart Meri's saying that international law is the nuclear weapon of small states, I think the core claim of the Baltic states seems to be that there shouldn't be a too stark deviation between great powers and smaller states in terms of how international law is applied and whether it is applied. Because and here, I think the Baltic states are clearly opponents to let's say Russian approaches to international law, previously Soviet approaches to international law, which I have studied for many years now, where the core standpoint seems to be that there are great powers, and great powers, they are special because they are so strong, so powerful, so they have special rights, permanent seat with veto power in the UN Security Council, but even more specifically, things like aggression. The bottom line really is that a permanent member of the UN Security Council kind of cannot commit aggression in a way that would also entail responsibility and international condemnation in any meaningful way. That would also include, some sort of enforcement or sanctions, something beyond what the General Assembly of the United Nations think. So, in some ways, in the 18th century, there was this famous Swiss international lawyer, Emmer de Wattel, one of the representatives of the natural law school, and he wrote this line that once one kind of becomes a person in the international legal sense, then this is in the international community. Great powers or big states and small states, whether it's a giant or a dwarf, they are equally persons in the eyes of international law. And I think the struggle of the Baltic states is that in the practice, in the relations, for example, also with the former Soviet Union, we did not feel that it was always the case. Because in the end, there was no. If you think in terms of articles on state responsibility that the International Law Commission adopted, and arguably in its core essence would reflect customary international law, that smaller nations sometimes make the experience that not everything works like that in the practice, as the theory says. And I think the core claim of the Baltic states as archetypical small states is to basically to insist that international law, its core doctrines, concepts apply to everyone. So great powers can commit aggression. They should be responsible if they violate international law. If I may, in this Oxford Handbook of International Law in Europe, which the introductory chapter for which is also online, I think open access at the Oxford University Press, there is a very interesting country section. There's also a country report on Poland by Władysław Czaplinski. I wrote the country report or statement for the Baltic states, so trying to look at it, how historically they have approached international law. Our main idea was to somehow tease out the soul for each those countries that we cover, which are not all European states, unfortunately, but many, including, by the way, Ukraine and many others. Some are also put together in like former Yugoslav countries or Nordic countries or Benelux countries.
In this context, I have a question regarding a little bit about double standards of Central Eastern European approach to international law, maybe even a little bit of hypocrisy. Why I'm asking this question? Because on one hand, we observe that after Russia aggression against Ukraine, Central Eastern Europe countries kind of got together and hold the flag of international law really high. They were really active in the UN, in the ICC, in the ICJ, in the Council of Europe, constantly highlighting the necessity to support Ukraine to the fullest extension possible, to gather this support to hold responsible those who are violating international law, responsible of a crime of aggression and war crimes. They start to use their even own domestic legal system in order to reflect the universal jurisdiction. So they basically consider to be a champion of international law at the time, flying this flag of international law really high. But as the time progressed and as we are facing now a huge geopolitical changes and of course crisis, a very serious crisis in the different areas of the world, we kind of see that this, let's say, this posture is not the same, as it used to be. I will give here two examples. One example is the question of disarmament treaties, international humanitarian law. It is known that the Baltic States, Poland, and Finland also decided to withdraw from Ottawa Treaty, prohibiting the landmines, and Lithuania on the Convention on Cluster Munitions. So you may say it as an external observer that, okay, on one hand, you've been praising international humanitarian law, but on the other hand, you're withdrawing from the treaties of international humanitarian law. The same issue is the right of asylum. Well, the question of the landmines, of course, it's sparking a lot of emotions, but I would rather say, and I think you agree with me, that there is a unanimity in terms of social and political circle that actually this is a correct step. And of course, nobody wants to sound unpatriotic because the threat is obvious. But on the other hand, from the pure international humanitarian law perspective, this is somehow a step back because I believe landmines were inhuman weapons, are inhuman weapons, and they are going to be inhuman weapons in the future. But I think this is let's say another issue, and those security considerations prevail. Other aspects, as I mentioned, is suspension of the right of asylum, which also happens in the Central Europe. This kind of trace me back to the time there is a question whether we are really repeating history, and I hope we are not going to repeat the history. I'm talking about the pre-war times, because during the pre-war times, also Poland, Baltic states, they were really, as you said, use international law as a substitution of the weapon of mass destruction. And they were really into the League of Nations system, Treaty of Versailles, many, let's say, bilateral or multilateral treaties regarding, for instance, the definition of aggression in the 30s. But as the storm was approaching in the late 30s, actually those nations kind of changed its attitude. And for instance, the Baltic states and the Scandinavia, they decided to turn back from the system of collective response, from the acts of aggression, and declare neutrality, which was believed the only right choice at the time, given what was happening in the Europe. And by the way, on this regard, I think we could say a story about the Polish submarine Orzeł, which entered in the middle of September Tallinn, and the commander of the Polish submarine, he was unaware about the Estonian rules on neutrality, and because of that, the whole situation got Estonia really into huge trouble. It was actually a pretext somehow of Soviet annexation, because the Molotov said, oh, you cannot control your territorial waters because you allow a belligerent warship to freely roam on that water. So the question is, well, in time of emergency, in time of a threat, is there is a tendency in this region that on one hand we are holding the flag of international law really high, but on the other hand, well, if there is an emergency, we kind of said, well, not anymore.
That's also another very interesting question, but I sense that there is a kind of underlying assumption to this question, or this way of asking it, that international law is somehow always or mostly a force of good, and maybe it is, but I would question whether things could be more complicated, in the sense that one can do different things with international law. There are different visions of international law, and also the international law can mean different things in different time. So a choice has to be made. What kind of international law does one want? I'm thinking of my favorite example from the history is that, the partition, the three partitions of Poland, they were in some sense carried out via the means of international law, because these were treaties concluded in St. Petersburg between the Russian and the Austro-Hungarian empires. So basically treaties were concluded the leading Russian imperial international law scholar Martens published the text of those treaties in the end of the 19th century. So in a way, that was international law. Yet for Poland, this was an act of utmost injustice. Their nation had been subjugated to another nation. And I think what is true about your question is that maybe especially smaller nations, when they are often in a kind of vulnerable position, their national discourse sort of is sometimes not critical enough or self-reflective enough, or you cannot, if you go to public saying that, look, maybe we shouldn't do that, then you know somehow. Well, then someone will write that why is this person even a professor or something, because why does she talk such a nonsense, right? And I think that small nations, like all nations, they have to, of course, maintain this critical self-analysis also when does something indeed become hypocritical. By the way, to those examples which you brought, the asylum issue and those weapons in international humanitarian law, I think from the viewpoint of global South, some countries noticed there that our region is much more into Ukraine than into, for example, expressing very strongly about the situation in Gaza, for instance, right? So there is also this what kind of cases one is bringing forward as violations. But other than that, I think that unfortunately Russia's war against Ukraine, its cruelty, its effect on civilians, its merciless deaths on many fronts. I think it is. My feeling is that it is a legitimate decision, at least as a policy decision, because in terms of when we talk about landmines, because abstract principles of humanitarian ideas are a nice thing, but there is also a need for self-survival, self-protection, right? And I mean, of course, the very bottom line of international humanitarian law is that somehow we think of those principles of humanity in the war. We separate between jus ad bellum and jus in bello. So in a way, the idea is that whoever starts it as aggressor, the rules of IHL would be somehow, they would essentially be applicable on both sides. But from the perspective of a smaller state, of course, the message to a bigger neighbor is that don't start aggression. Then these things will not have to be used. And in fact, it is very telling that those states, they did not want to cancel their participation in the Ottawa Convention, earlier, when this was not an issue. When you get daily threats from the likes of Vladimir Solovyov in Russian state TV about who might be next, then I think it is legitimate to actually protect oneself with the kind of weapons that are available, and of course also considering the fact that then why don't we criticize the fact that, for example, the Russian Federation never became a member of this Ottawa Convention. So there is always this question of reciprocity, symmetry in international law. But to the extent that I know, it's a very recent, I think, decision is that this decision has not been made, very, very lightly. There was a lot of consideration that went into that. But to wrap up my thoughts on this, I think that all nations, big or small, we all, it's maybe a human quality. We do have a tendency of being hypocritical when we can. We want to argue from the point of view of our interests as nations and so on. And we don't, so to speak, see our flaws so easily. And I think here, what I genuinely believe is that democracies have an advantage because the space to disagreeing, the space for also really criticizing state policy on some of those issues is bigger on in a democratic space rather than in places where this might criticizing state policy would make one end up in prison or worse. And therefore, my hope and my call for Central and East European states, of course, is to keep the democracy they have and to work further on improving it, making it, keeping it a safe space to also disagree and criticize the governmental decision without being a traitor.
Thank you for your comment, for your answer. And having in mind what you have just said about the threats of the Russian Federation towards the Central and Eastern Europe, and of course your extensive experience in the research on the Kremlin's approach to international law, regardless of the formal name of the Russian state, whether it was the Russian Empire, the Soviet Union, or the modern Russian Federation. My question is whether, and basing on your research and your experience working with the Western scholars of international law, do you think that the Western academia is aware of the peculiarities of the Kremlin's neo-imperial attitude towards international legal system, international institutions, as we can see from, let's say, the geopolitical point of view, the question of the peace, the so-called peace negotiations between Ukraine and the Russian Federation, and of course, the involvement of the United States in these talks. I can discuss this thing, or I can be very doubtful whether actually Washington D.C. is aware of this attitude of the Kremlin. Also, I have my own experience in the research, in the field of research of the genocide studies and the question of the genocide, especially in the context of the Russian crimes against the Ukrainian nation. Just yesterday, I was participating in a great webinar in which Professor William Shabas was giving his speech on the developments on international law in the area of genocide. And when he was asked by the Ukrainian participants whether it is possible to seek the accountability of the Russian state or very concrete individuals for genocide against the Ukrainian nation, especially having in mind the transfer of the children, the forcible transfer of Ukrainian children by Russian Federation, Professor Shabas said this issue is out of the question. So it was like, very, very from the bottom rejected by an outstanding professor of international law. So getting back to my question, do you think that the Western scholars are aware of this attitude of the Kremlin, which is different from this classic Western understanding of international law, and basically the division between law, morality, law and politics, which of course it does not appear in the Russia's approach to international law. So what's your position on that issue?
Yeah, that's a long conversation potentially, but and I want to say here that I have actually, over the last years, I have worked on another monograph, which we are now talking in early June 25, but I think in October, my sort of another monograph on the history of international law in Russia and the Soviet Union will be published at the Oxford University Press, a book called Russia, the Soviet Union and Imperial continuity in international law, which tries to clarify that history, the history of how in Russia international law doctrines were used. For example, what was the relationship to treaties or state identity, state continuity, which is especially, I think, an important question regarding the Soviet Union, because there is not all lawyers are necessarily aware, especially who did not have personal encounters, or whose ancestors didn't have personal encounters with the Soviet Union, who look at it from faraway countries or something, that there is a certain amount of romanticization of what the Soviet Union represented. And I think what is not noticed sometimes is that the Soviet Union could be pretty imperialistic in some contexts. If you think of its doctrines in like socialist international law, which said that Hungary and Czechoslovakia, but also Poland, they cannot change their government, they cannot switch from state socialism to capitalism, and if they will want to do so, then there will be a military intervention, or how during various periods Russian and Soviet international legal scholars have justified the unilateral termination of treaties when the state interest, as it was perceived, so demanded. Somehow this Russia, as well as the Soviet Union, they have escaped this otherwise very critical scrutiny of imperialism and even colonialism. I mean, we can easily say that although the Russian Empire officially did not have colonies, but in essence, Russian Empire's extension, let's say in Central Asia or in Far East or in Caucasus, it was really a colonialist matter with colonialist practices, but somehow. For various reasons. One of them being that while the Western colonial empires they came to an end in around 1960 to a large extent, then in some ways the Soviet Union was the more successful empire. It lasted until 1991, and I think it will be actually something for the coming years and decades to still discuss with this. Ask about the consequences of this imperialist legacy. I think there is a certain amount of naivete in some Western colleagues I have sometimes encountered. They basically, they think about Russia more in terms of some nice colleagues they have met and a good time they spent, visiting Moscow and St. Petersburg. It's also that, the European past was really made by European empires, European great powers, and Russia belonged to them, maybe until 1917 more than after that. After that was this antagonism with the Soviet Union, and also to some extent isolation of the Soviet Union during the interwar period. But there has been also a lot of this goodwill that has been there on the side of many Western international lawyers, that basically, especially after the collapse of the Soviet Union, one needs to somehow work to maintain human relations, to basically interact also with Russia, to recognize also the positive perhaps contributions that Russia historically made, including in international humanitarian law. But I think this war against Ukraine should be, I don't know if it always is, but should be a sort of clarion call for people to investigate. Why do things go wrong there in this idea of Wandel durch Handel, as the expression is in German, that we'll have as good relations as possible. will get mutually entangled, and then there will be peace, and then there will be mutual interest and prosperity. And somehow, several times in history, Russia as a state, it tends to fall back to this imperial essence, also, threatening and discovering somehow that its previous borders were drawn at the time of weakness, although it was done all by treaties, which Russia itself signed and ratified, and then it steps up as a revisionist power. So I think it's high time that we ask without any mercy, very, very openly and critically, what is, or see also this, let's say, liberal imperialism in the case of Russia, that actually even people like Navalny, may he rest in peace, while they were very critical of Putin's corruption, some of their views were also in some ways, in terms of peoples earlier subjugated by Russia, they were imperialist. So I think that more frankness and facing facts will be needed in the future, but this is also the job of basically lawyers and historians, by the way, also from Russia, because in the end, I don't think that scholars from Poland or Estonia or even Kazakhstan can do all this work, but I think that in the end, there will also be some sort of amount of material that can only be accessed from within Russia to unearth these histories. But of course, in the present conditions, this is not possible to do this kind of research that is critical of Russian imperialism and in international law from within the Russian Empire. So a little bit, I would also be critical of colleagues actually who maybe, they like to say that, but why hasn't Russian imperialism, for example, or Soviet imperialism, why hasn't it been condemned? But my counter question is that have people done enough to also demonstrate what has happened, historically? And I am not sure the answer is yes. By the way, in terms you mentioned genocide, there is a very interesting book by a scholar who is working in Norway, Anton Weiss-Wendt, the Forging of the Genocide Convention, which demonstrates, actually, is a lot about how the Soviet Union, with its own interests, shaped the definition of genocide in 1948. So it is definitely also, and it is actually coming back to this previous question, that's about hypocrisy in international law. Well, some of the in some ways, all international law reflects power, reflects this consensus that existed at the same time when something was agreed. Well, in the case of the Genocide Convention, the Soviet Union insisted that social and political groups would not be covered by the definition of genocide, but ethnic, religious, racial, and national groups would. I mean, what I think is very peculiar about Russia's actions in Ukraine is this ideology of somehow denying the Ukrainian state in a way that what I think Putin himself called anti-Russia, that if Ukraine would choose to be in that sense completely independent, for example, join with the West, rather than stay in the Russian, let's say, family of nations, that this is somehow unacceptable to Moscow, to the extent that then as a punishment somehow Ukraine basically loses the right to exist. So I think it is very important to ask what is how this kind of ideology of denying Ukraine's self-determination essentially is also leading to crimes.
And our last question regarding peace in Ukraine. Is there a potential for Central Eastern European states and academia on intellectual and political level to shape the peace process between Russia and Ukraine based on this paradigm of just peace, which in my opinion is a little bit tricky element from perspective of international law, because we have to take into account that from theory of international law, how the conflict in Ukraine should end, how the aggression should end is pretty straightforward, and it's quite easy to interpret. I believe we kind of face a possibility, unfortunately, a real possibility that this paradigm of just peace may actually entails a sacrifice on the part of international law, which will have possibly maybe a long-lasting severe consequence. But can we see a room for this Central Europe approach to international law? Can we see somehow fit the process and shape the process? And also within the context of the special tribunal for the crime of aggression in Ukraine. And again, a question of maybe perception, external perception of other parts of the world, stating, okay, you are especially affected, if we could paraphrase the famous ruling of the International Court of Justice, you're especially affected because you are under threat of Russian aggression. But on the other hand, should all the states be especially affected when we have such a grave breach of international law as a crime of aggression? Where is the way? Is there a way of Central European approach to international law in this context?
Yes, I think that it is difficult because international law since the end of World War II has really developed in the way that condemns aggression, threat and use of force, annexation following threat and use of force. And also international law has developed with concepts like peremptory norms or jus cogens. And I think for example, in articles on state responsibility, there is this idea that actually there is an obligation for states not to recognize results of the violation of jus cogens norms. So clearly, the situation in Ukraine, for example, in terms of Russia's territorial conquest, it has far-reaching potentials, because if Russia manages to sort of consolidate its conquest also legally, then I don't think that international lawyers can as easily teach what they have taught about these things for decades. That this cannot basically find recognition, or this cannot happen. So, yeah, I would say that from the perspective of theory, the only just peace after an aggression should be the defeat of the aggressor. It is that Saddam Hussein's Iraq intervenes in Kuwait, occupies and annexes it, and then the international community decides to send forces in there by some mighty states representing the international community. The country gets liberated, Kuwait, and then basically, in that sense, previous situation is restored. And at the moment, it's really not sure that it is such an outcome. It is ever even possible against a great power, against a power whose status is a special one, even based on this constitution of the international community, the United Nations Charter. But the charter doesn't actually give this kind of right to its permanent member either, to commit aggression, to start a special military operation, as it is called in Russia. So I think that the overall line of Central and East European states will for sure be that let's stick to those rules which have been developed in international law, which also defend defend smaller states, their territorial integrity, even if they become victims of aggression. So that a huge difference can emerge from that, namely, bigger neighbor can then be perhaps successful in material power in conquering, let's say, some of the territory, but I think it still makes a huge difference in international law whether this is recognized or not. So in that sense, I think this Trump's initiative, the US moves currently to create peace between Russia and Ukraine, these are very significant, not only for the situation in Ukraine, but also for what will happen to those rules that, by the way, the United States itself was crucial in actually proposing and creating, starting from the 1930s with the Stimson Doctrine, and then with the Sumner-Wells Declaration in the case of the annexation of the Baltic States or occupation of the Baltic States in June 1940, and so on and so forth. So a lot is in stake here, and I think that it is the very, very geopolitical position of the Central and East European states as sort of smaller states that dictates that they will, in that sense, take the position that international law must be protected, also in terms of territorial integrity of states who have become a victim of aggression. And by the way, no one, in principle, can command Estonia to recognize, let's say, if some pieces of Ukraine would be taken away by Russia de facto. So recognition, it's still individual in the international community. So I think even if hypothetically, if the United States would say that, well, we are willing to consider, let's say, the recognition of Crimea, if that ends the war, then I think that in the end, each state also has the capacity to decide it on their own, how they relate to that.
And we are slowly concluding our episode. In my opinion, it is showing that there is a lot at stake, I would say, in the context of Central Eastern Europe and international law. And I think maybe a key word of our talk today is what you said about perceiving international law in this region as a substitute, as a nuclear weapon of those nations which have common history, being under occupation, being under imperial dictate. And I think our talk with our prominent guest, Professor Lauri Mälksoo from University of Tartu, highlights what is at stake and how important and how is also significant to discuss those issues related to the Central Eastern European approach to international law, where the region, which in fact, in a fascinating way, the politics, the history, and the law connects. So thank you very much, Professor, for being a guest to our podcast. It was a great pleasure.
Thank you so much also on my side for inviting me and for the very interesting questions, which show that you are really also thinking hard about those things yourself. So I hope we'll continue this conversation another time.
Most definitely. So with this, we are ending our episode. Thank you very much for listening. A few words in Polish. Szanowni Państwo, dziękujemy za wysłuchanie odcinka. Zapraszamy do następnych odcinków. Dziękujemy. Thank you very much.